Benedicto Batara-Ocampo and Daisy Garcia-Ocampo vs. Noblesa Batara-Sapad and Ernesto C. Batara. GR number 256343. April 2, 2025. Marcos Batara owned a 1-hectare parcel of land in San Jose City, Nueva Ecija, covered by TCT number NT41863. Upon his death in 1974, he was survived by his children, respondents Noblesa Batara-Sapad and Ernesto C. Batara. Both were minors at the time and unaware of their father's ownership of the property. In 2007, Noblesa received a notice from the city treasurer regarding unpaid real property taxes on the land. Upon inquiry, she discovered that her cousin, petitioner Benedicto Batara-Ocampo, and his wife Daisy Garcia-Ocampo were occupying the property. Benedicto claimed that he bought the land from Marcos in 1972 for 40,000 pesos, allegedly paid in installments until 1985, with the first payment of 3,000 pesos given directly to Marcos, and the rest to Marcelo Batara, Marcos' brother. However, the sale was never put into writing. Noblesa demanded that Benedicto vacate the property or pay her the purchase price, but he failed to do so. Consequently, she filed an action for recovery of possession in 2013. The city court ruled in favor of Noblesa and Ernesto, holding that registered lands cannot be acquired by adverse possession, and that the undocumented sale had no legal effect. The RDC affirmed the decision, finding that Noblesa and Ernesto, as heirs of the registered owner, had a better right to possess the land. The Court of Appeals, CA, likewise affirmed, ruling that Benedicto acted in bad faith by paying Marcelo, who had no authority to receive payment, and that the alleged sale was unenforceable under the Statute of Frauds. Benedicto and Daisy then filed a petition for review on certiorari before the Supreme Court, claiming that the lower courts misappreciated the evidence and that the oral sale was valid and ratified. Whether the alleged oral sale between Marcos Batara and Benedicto Batara-Ocampo was valid and enforceable, thereby entitling the petitioners to ownership and possession of the property. Yes, the Supreme Court held that the lower courts erred in disregarding the testimonial and circumstantial evidence supporting the existence of an oral sale. The court ruled that under Articles 1358 and 1403 of the Civil Code, contracts for the sale of real property must be in writing only for enforcement purposes, not for validity. Thus, the oral sale, though unwritten, was not void. Citing Almaral v. Montserrat and heirs of Alito v. Campano, the court explained that the statute of frauds applies only to executory contracts. Since Benedicto had already taken possession of the property, received the title's owner's copy, and paid a portion of the price, the oral sale was deemed executed and therefore valid between the parties. However, the court found that payments made to Marcelo after Marcos' death were ineffective because Marcelo was not authorized to receive payment on behalf of the heirs. Hence, the obligation to pay the balance of 37,000 pesos to Noblesa and Ernesto subsisted. The Supreme Court ruled that Benedicto and Daisy must pay the unpaid balance of 37,000 pesos, with legal interest of 12% per annum from December 31, 1982 to June 30, 2013, and 6% per annum thereafter until full payment. Upon full payment, Noblesa and Ernesto are ordered to execute a deed of sale in favor of Benedicto and Daisy, thus giving full effect to Marcos' original intent to sell the land. Thank you for watching. Please like and subscribe for more case digests.